Hello, Professor. Good to see you.
Same here, same here.
I can't hear you. I don't know why. Professor Anita, I can't hear you. I mean, is it my problem? I don't know.
You can't hear me also? Can you hear me?
Jagdish sir, sorry for the interruption. Huh? There's some technical problem.
Because I think sir did not listen what actually it was. Probably because of that. Nothing to
We'll
it.
just solve this and then we'll go with the formal.
Yeah. Yes, 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 yes. Not much.
Surya, can you talk to sir?
Somaseka sir, you can please just exit the meeting for just a few seconds and rejoin back. 90% of the time the problem gets solved. So you can just exit briefly and in another 5-10 seconds try joining back from the same link that I sent you, sir. Thanks. I think Somaseka sir is not able to hear us also. He's just written a message on the chat that if we can hear us, if we can hear him, we may please proceed and start. I think he's not even able to hear that I requested him to exit and rejoin.
Did he exit and rejoin?
No, ma'am, he didn't because I think he's not even able to hear us.
You can call him and talk with him. And I've said
Sir, please
I
call
think you
him.
can call him once and then I think he'll be able to.
Ma'am, I've already sent him the messages on the chat. I've informed him to rejoin. I think he's seen and exited. Let's wait
All right.
to rejoin.
All right, we'll just wait for 2 minutes. Yeah.
Am I audible now? I've
You are audible.
exited and rejoined. I hope this is working.
You are audible?
Nope, I cannot hear you.
So I think there might be some connectivity issue from his end. I'll type him on the chat because he has said that we can proceed if we can hear him.
He can't still hear us, isn't it?
I don't think so, ma'am. Usually this solves the problem most of the times if you exit and rejoin, but
No, Stay, actually, if there's a connectivity issue, video won't be visible. No, he is very clearly visible and probably there may be other technical issue. I think
Ma'am, I'll just ask him to rejoin from another device. Probably if there's a hardware issue with his device, he can join us from a mobile phone or some other device. Just give me a few seconds, I'll type the message to him.
He might not be comfortable with a mobile, you know.
Ma'am, I've informed him that there might be a hardware issue with the device that he's using, and if he can use a second device to log in. If Hitesh sir can, I would request him if it's possible for him to call and convey this message also.
I've given him.
Just check. Yeah.
He's logging through mobile. So he will use two instruments. I said that.
Right, sir.
Just check it in attend if he has joined or not like that.
Yes, sir.
Just a minute, I'm getting settled in on my mobile, but
Yes,
I
we
just
hear
rejoined
you.
using the link that was sent. If you think all is fine, maybe I can just start.
Okay. I've already sent him the attendee link. I'll just type it out with him.
No, I can't hear you, Shrey, so. Okay. Okay, I have joined. No, it says on the mobile, it says meeting not found. I just tried on my mobile. Let me just start. I mean, anything that you have to say perhaps can just be put up on the chat. I'll be constantly looking at the chat. It's already 10 minutes past 6:30, 6:40. So if you're fine, I mean, you can just start. I'll try again on my mobile.
You can
Hitesh
go ahead.
sir, why don't you call him now once?
So I already talked with him, but I don't know why in mobile it's not. I've given him link also.
Jagdish sir, is it okay that he starts and then we
Yeah,
conclude?
no,
Is that all right?
Fine, madam.
No, we have to take formal registrar in charge
Yeah.
because of this.
Okay, so I've got my mobile up and running.
Because sir is unable to hear us also. So Shrey, be careful, it doesn't happen in our plenary sessions. Shrey?
Yes, ma'am. No, ma'am. I've already cross-checked the links. It's a hardware issue from sir's end because everyone is able to connect. It's the problem is only arising from his end.
No, till now no such problem happened, but since happened now, it might happen in the subsequent sessions also.
Right,
That's all
ma'am.
I'm trying to say.
I'll make sure, ma'am. I'll make sure to.
2 more sessions are there. No, stay. Just make sure that
Give a message to sir to start, to please start if he can.
Okay, ma'am.
He's speaking, we can't hear him.
I mean, I can hear you.
He was
Can you hear
muted.
us,
So
sir?
yeah. Okay.
Can you hear us?
Yeah.
So let's go ahead, sir. Can we start your session?
Let's go ahead. Okay.
Just can you give us 1 minute? We want to give a brief introduction. Can you complete the moderator?
Sure.
Yes, sir, I'm here. A very warm and a good evening to you, Dr. Suma Shekhar. I extend a very warm welcome to you on behalf of the GNLU Center for Law and Economics to the valedictory session for the 5th International Conference for Law, Economics and Public Policy. I would like to call upon Dr. Suma Shekhar for the very first speaker series. To introduce him, he has over 20 years of experience in teaching students of economics and law and is a professor of economics at National Law School, Bangalore. Spanning his career, he has been the Erasmus Mundus Fellow at the Institute of Law and Economics at the University of Hamburg, an advisor to the Ministry of Commerce and Industries to the Government of Karnataka, a two-time United States International Visitors Leadership Program participant, a global visiting professor at the Denman School of Law, and a member at the Indian Council for the Cultural Relations and the chair professor at Sciences Po Paris in 2011. His publications and research reports are in the area of competition law, particularly related to e-commerce and technology sectors and other areas of regulation. We are very glad and honored to have you today, sir. Thank you so much.
Thank you. Thank you very much for the kind introduction. It's my pleasure to be here today. I have, of course, been associated with the GNLU Law and Economics movement for quite some time and happy to be here in this capacity as well. And my apologies for the technological issues, but we can get started straight away. So what I'm speaking about today is something which is very current, very contextual. It is about the case that Apple is currently facing with the Competition Commission of India with respect to the pricing of its services. And the reason why I have chosen this is because it is relevant for students of law and economics from both a theoretical as well as an empirical perspective. It shows how important your theoretical foundation is. You need to get your theoretical foundation, correct in order to be able to proceed in the general sphere of law and economics. And then how important empirical analysis is in the sphere of law and economics as well. And both of these are very important in this particular case. So just to give a quick background, this is based off a recent blog piece which I wrote for the NLSIU blog a little time back. But anyhow, basically, what's happening with Apple is that basically, it charges a fee when people who basically host their apps on the iOS platform. So the iOS platform is owned and operated by Apple, and it is an exclusive platform in the sense that unlike the Android platform, which is licensed out to other smartphone developers, the iOS platform is not, or the operating system, iOS operating system is not licensed out for other smartphone or tablet developers. So those who host their app developers who host their apps on this iOS platform, if people use these apps, consumers use these apps and they try to download, or they try to use an in-app purchase, right? So quite a few of you all may be familiar with this. You may play a game, or which says, okay, if you want to purchase these, um, digital coins, well, you got to pay money. So when you engage in that, Apple charges a 30% transaction fee, right? Now, the complaint against Apple is that this 30% fee is excessive. And this excessive fee is born essentially out of Apple's dominance in the market, which uses basically iOS, the iOS operating system, right? So the claim is that, the fancy term that is used for the Apple's ecosystem, basically all those services which are linked to the Apple's iOS platform, um, is called as the ecosystem. It's described as a walled garden, in the sense that it's a pretty garden, it's beautiful services and products, but once you get into this particular garden, it has a very high wall, right? So it is a walled garden, in the sense that it makes it very difficult for you to later get out of this particular garden. So if it's difficult for you to get out of this garden, it means in an economic parlance, or in an antitrust parlance, it basically means that Apple has dominance. Apple has enough market power to charge you excessive prices, right? And there's nothing much that you can do, because the walls are so high, you can't get out of it. So the walls analogy is basically used in the context of the inability of a person, a consumer who's using products of the Apple ecosystem, to switch to an alternate product, because switching is very expensive. So if it's so expensive to switch, you would rather pay the high price than move out of the Apple ecosystem. And they say that therefore, based on this dominance, Apple is charging this very high fee of 30% for every in-app purchase, right? So that's the whole, issue over here. But the problem is that it's a complex problem, in the sense that it involves a platform, right? So, and in the case of platforms, we unlike in traditional antitrust issues where there's just a buyer and seller, well, it's very easy to define the market. But when it comes to the context of a platform, there are, we call them as two-sided platforms or multi-sided platforms, which essentially means that there are different players are using this particular platform, whose acts have an externality on the other users of the platform. So in this particular case, definition of the market becomes quite complex. So we'll come to that in a little while, but it's not that Apple is really being investigated only in the context of India, but Apple has faced investigations, or is facing currently investigations by agencies across the world, and has also faced action by certain governments, regulatory authorities, which are non-antitrust agencies or competition law agencies. For instance, it's currently facing complaint laws with the EU Commission. All right, so it is a similar complaint, and the complaint is that there are high in-app purchase fees that are being charged, and plus that there are anti-steering contractual rules. So when an app developer hosts an app on the iOS platform, they have to route all the payments through the Apple payment gateway. They cannot divert these payments through an alternate gateway in order to escape this 30% fee, or even indicate to the users, look, there is a potential alternate gateway that you can use. So that you cannot even do that. So those are called as anti-steering contractual rules, right? And these and the apps which challenge this were, and the sort of apps which were, related to in this complaint, were music streaming and ebook or audiobook apps. All right, and then you have also a similar complaint with the UK Competition Markets Authority as well. All right, on similar grounds. And then in the case of the Australian Competition and Consumer Commission, well, they initiated an inquiry, not because there was a complaint, but they initiated an inquiry. And very interestingly, what they found was that Apple and Google, all right, they both have significant market power in the marketplace for app distribution. So in the case of Google, you have a particular app platform, and in the case of Apple, you have a different app platform, the App Store. And so they say that each one of them has significant market power in their own app stores, right? So, and therefore, but they didn't get into the issue with respect to excessive fees per se. Right? So they just said, they have significant market power here. And therefore, what they recommended was that they insisted that these two, Google in the case of Android-based devices and Apple in the case of iOS-based devices, must improve transparency with respect to alternate payment mechanisms that are available so that people can use alternate payment mechanisms. And in that case, when they use alternate payment mechanisms, the fee may be lower, and therefore the overall price that they got to pay for these in-app purchases are also going to be lower. So that's what they're insisting on. In the case of Japan, similarly, there was a similar complaint, and Apple agreed for a specific category of apps, so they're called as reader apps, that, okay, we can provide for them to make their payments through an outside website. All right, and so, but that's all. It doesn't link it up to all the apps, just a certain category of reader apps. Reader apps are basically subscription apps. You subscribe to these apps and, like say Netflix or something, and then you continue to use them. All right, so it only provided a concession with respect to that. All right, so now I'm going to skip certain things which I had to say given the time constraint that we've already passed through. And in the case of South Korea, well, the government simply said, well, look here, you guys got to remove this. All right, so they looked at certain types of actions by Google and Apple, which were, for instance, unilaterally they would delete certain apps, or they would cause delays in the approval of apps, or also insisting on the use of their own in-app purchase mechanisms. All right, so they said, no, you've got to remove that. All right. Now, in response to that, Google said, look, please try to understand the economics of platforms. We are able to provide the Android operating system for free to smartphone, OEMs, original equipment, for the simple reason that we are able to generate revenue through these mechanisms. All right. But the South Korean government was not really convinced by that. And Apple, however, has refused to reverse its decision of, removing a particular gaming app, which is owned by Epic, and Epic is the one which has challenged Apple in the US as well. And in this challenge, Epic Games versus Apple Inc., what the district court basically said that, Apple should provide external links, website links for payments. All right, but it didn't really say that Apple is dominant. Now, so what we are seeing is that different countries and different agencies seem to be having different kinds of approaches towards how they tackle this particular case with Apple. So in the case of Australia, we saw that they say, okay, Apple is dominant and Google is dominant. In the case of European Union, in an earlier case, they said Google is dominant in the case of the Android app system, because iOS is completely distinct. It is not available to other smartphone users, and most likely the EU Commission is likely to be, guided by that. And in the case of Korea, it's a different approach. In the case of Japan, it's a different approach. And in the US, the case leads to quite a different approach where Apple is really not called as dominant at all. Now, this is very interesting. Now, it's very interesting for the simple reason that we believe that antitrust and competition law across the world is increasingly being guided by economics and the current development in economics. Yet, at the same time, we notice that there are different sorts of results that are being thrown up by these different countries. So which sort of asks the question, what exactly is the difficulty involved over here? All right, so we'll come to the theoretical difficulty
that is involved over here. But before we come to this particular theoretical difficulty, we have what you also have, what you call as the Neo-Brandisian school. So some of you might know that, well, two important contributors to this Neo-Brandisian school of late, and in fact, they're the ones who have, renewed interest in this particular approach in competition law enforcement or antitrust enforcement, are Lina Khan and Tim Wu. All right, so what are they basically saying? They're saying, look here, antitrust or competition law being guided by consumer welfare as the overwhelming guiding principle in enforcement is not leading to desirable results. Look at where it's got us. Look at the size of Google, Facebook, and Amazon, and Apple. They have all emerged as what you call as gatekeepers, and as gatekeepers to certain particular digital markets. They, since they're the only gatekeepers, people who have to get into this particular digital market are charged excessive prices. That's what the US, in the US, the House Judiciary Committee of the House of Representatives found. So there was a long hearing there in the case of the US, and they said, yes, these are all gatekeepers in the sense that they're dominant. They have monopoly power. That's what they call them. It's called as in the US. All right. So, and what do they find? That they are respective, they're dominant in their respective app stores, and they're also engaging in what you call as self-preferencing, trying to, using their gatekeeper status or the dominant status in order to prefer their own verticals. So a lot of allegations were made there, and they seem to have been driven to some extent by the Neo-Brandisian school, which said that, not only is the consumer welfare standard being excessively used, but what is leading to is essentially under enforcement. So they're saying we must now focus on over enforcement, and we must try to protect what you call as competitive process, and must try to encourage startups, and must try to encourage potential and nascent firms. This is a very significant shift away from the way in which competition law is being practiced currently. And it leads to dramatic change in the sense that it could lead to uncertainty in the way in which competition law can be enforced, because when you try to have these multiple objectives instead of the consumer welfare principle, you can have a lot of uncertainty that can come up. But there's been a lot of criticism of that. But coming to the theoretical difficulty that we're facing over here is in the definition of platforms. So what's happened is, as the definition of platforms developed, and then based on that economic theoretical developments, the definition of the relevant market also underwent changes. So gradually over a period of time, it sort of antitrust economics sort of settled down to dividing these markets into transaction markets and non-transaction markets. So transaction markets would be something like e-commerce platforms, where consumers buy and they engage with the seller. So there is a transaction involved between the seller and buyer, and the e-commerce platforms are the intermediaries. And then there are non-transaction platforms, like say, for instance, an advertiser and a web user. There's no direct relationship between the advertiser and the web user. So they said that in the case of transaction markets and non-transaction markets, the definition of relevant market should be different. But however, now the challenge is that they say that no, you can't. That is a spurious distinction that's being made. So that's the first part of the theoretical challenge. Now, the second part is the empirical challenge. Now, based on the relevant market definition, you got to then get into the empiricals and then determine what is the product market. Now, what we saw in the case of the US court decision was that there was a big mess where economists who actually argued elsewhere in their own academic papers that this is what should be the relevant market and this is what a test of this nature would reveal. In the courts, they actually went contrary to what they argued. The empirical presentations were used in a completely different manner. Now that became problematic, and the court actually, threw it out. So the difficulty that the Competition Commission is going to face in the current situation is in getting this definition of the relevant market right, based on the appropriate approach towards how exactly they would define a transaction and non-transaction platform. And then on the basis of that, determine if Apple has sufficient market power to actually engage in this 30% charging of fees. And the next thing that they got to get into that is once they say, okay, this is the fee, this is the relevant market, then they got to get into the issue of excessive pricing. Now that's again tricky. The Competition Commission has not engaged in excessive pricing as of now. And in the case of the US, excessive pricing is generally, just pushed aside, saying that the markets take care of such issues. So, when you get into the area of excessive prices, you get into all sorts of tricky issues as to, if you call this as excessive, then what is a comparative price? So it's going to be quite complex and it'll be interesting. And I'm just presenting these preliminary ideas to the audience over here. And I'm thankful to everyone for listening to what I have to say, because the decision over here and the decision in the European Union can lead to quite a different approach towards the pricing behavior of platforms. And this different approach in turn can lead to a completely different position of these platforms in the way in which they charge people. For instance, can Google go ahead and pretty soon start charging people for the use of their search engine rather than simply derive their revenue from advertisement? So it can be quite a significant change in what, over the years, the way in which the competition authorities give decision. Our interaction with these normal services, which we consider as free so far, can change quite a bit. Thank you. I'll stop with that.
Thank you so much, sir, for such a valuable and insightful session. We all have benefited greatly from it. Now, I would like to call upon Dr. Chandra for his comments. Thank you.
Thank you so much. Professor T.S. Somashekar, guest for this palliative session, Professor Anita Nagar, Head Center for Land Economics, Dr. Hitesh Thakkar, convener for this conference, organizing committee members, participants, faculty colleagues, administrative staff members, supporting staff. I definitely understand there's a session already at 7 o'clock almost. So I think probably people are waiting there. So I don't take much time. I definitely wholeheartedly congratulate for the Center Organizing Committee for this 5th edition of International Conference on Law and Economics. Consistent efforts from the Center Director and other colleagues in the Center. They make it possible to have a 5th edition of this Center for Law, this international conference. So what I feel very strongly is actually this one side academically teaching law and economics in the BA curriculum is one side. That GNLU is definitely fortunate to have a center head, which she has taken up this and made it possible. And that is one side of that we are inculcating knowledge on law and economics to law students through curriculum. Other side, through other people who are not a part of the GNLU. For them, this kind of platform is really very helpful to understand the relation between law and economics. To be frank with all the participants who are present here, even I was not aware of law and economics concept actually. Although I am teaching law, but whenever there's a question of some kind of calculation comes, I used to understand it's the mathematics actually, because I'm basically from BSc background, physics, chemistry, mathematics. But actually, in fact, it was the economics. That it has come to know through probably when they introduced this law and economics, when I had discussions with Madam very long back, around 6-7 years back. So that time I got to know these are all economic tools actually. So then the subject which I'm teaching, especially insurance law, has a lot of connections with economic tools. Today also I was actually teaching in the morning when I taught the life insurance. I just thought of telling just 1 minute for that important point. That in a life insurance, we look at, while issuing any companies, today all companies are profit motive. We understand that. They want to make business in the country. They issue more policies for the people. especially for life insurance I'm talking about. But at the same time, they do not issue the more what's called as coverage for a person who is not earning actually. So what is that? It is an insurable value, we call it as. And where do you derive the insurable value of the person? The insurable value of the person can be derived through human value index. Where do you got this concept of human value index? It is again economic tools actually. So a person who is a laborer, who is earning 300 rupees per day, daily wager, cannot get 1 crore rupees policy for his life. But I'm drawing salary probably 1 lakh rupees. Even I do not get 1 crore rupees life insurance policy on my life. Because there's a restriction for them, for the companies to issue for me, because they're deriving the economic human value of me. That was in case of death, what is my value? That comes human value indicators, and then that what called as tools which they use for deriving that economic human value is a base for actually economics tools. So that's what, because of this economic law and economics initiatives taken by the center and various this kind of platforms, I got to know that those are the most important tools which law require. And then actually law is using, in fact, those economic tools in reality to strengthen the present present law system, which will give you a real solution for the people at large. So with this, I understand that already they're supposed to commence the next session. So I wish you all the very best for the next plenary sessions and for the entire team of Law and Economics for making this event more grand success. Thank you so much. Thank you very much.
Thank you. Thank you, Dr. Jagdish. Thank you so much.
Thank you so much, sir. So this brings us to an end for the valedictory session, and I invite you all to please stay back for plenary session 3 with Professor Thomas Ullen, and we would begin very shortly.
We can start, I think, sir, is there.
Yes, sir. A very good evening to respected speakers, attendees, and members of the organization committee. On behalf of the GNLU Center for Law and Economics, I extend a very warm welcome to plenary session 3 of the 5th International Conference for Law, Economics, and Public Policy. I would also extend a very warm welcome to our speaker today, Professor Thomas Ullen, the research professor at Swanland Chair Emeritus College of Law at the University of Illinois. As a scholar, Professor Ullen examines a variety of issues related to economics, legal scholarship, and legal education. He's a prolific writer and researcher, and we are very happy to have you today here, sir.
Can you hear me?
Yes,
Yes, Professor Ullen, warm welcome.
Thank you very much. Renita, did you get the the presentations that I sent to you, or should I run them myself?
We can run it. We can run it.
Just give me a presenter right now.
Okay.
Can I take 2 minutes if... Yeah, just give me presenter rights.
Sir, I've given sir the presenter rights.
Okay.
Thank you.
Before we start, thank you, sir. Before we start, I will also like to extend a very warm welcome to our faculty moderator today, Dr. Hitesh Kumar Thakkar, who is an assistant professor of economics at Gujarat National Law University with immense research and publication experience in economics, and more specifically law and economics. We're very glad to have you today with us, sir. Thank you. And I would like to invite you to take over the reins for moderating this session.
Thank you, Kusi. Sri, you have to make me a presenter. Still, I can't share.
So please try now, sir.
Yeah, it is working. I hope the screen is visible.
Yes, sir, it's visible.
So before you start, sir, I had made a small presentation.
Yeah.
And I know that I don't want to waste of time of the people who are eagerly waiting your presentation. But I could not stop to make few comments. And in fact, you are taking a topic on nudge and mandate, complement versus substitute. So I don't know as a moderator what to speak, I think, but still, I thought let to tell something which is which has helped us. So I don't know what is nudge and how Richard Thaler has got and what is his contribution. But like for us, me and Ranita madam, when we started learning law and economics, and we found one of the best book which is available was Law and Economics by Kutter and Ulan. And I think we started with the 4th edition, and then we started with the 6th. So I think in all that journey, I think the way the Ulan sir has helped us, I think it can be given in any name, but for the GNLU and for GNLU Center for Law and Economics, I think that is what nudge is. I think one of the Ulan sir session which we organize online, I think the way we the center members and we were making the notes, I think that do prove that how far we were so much interested to learn law and economics. And I think it is great that the nudge theory may work, their behavioral approach may work, but I think individuals who are there who do help us makes that it does not limited to them, but it do reach out to the rest of the world. And in that regard, I think we are greatly thankful to Professor Thomas Ulan for I think helping us for developing law and economics in India, and at least shaping the Center for Law and Economics. And whatever the limited things we are doing, I think your blessing, your mentorship, your guidance do help us. So with that, I may invite sir to take forward from this, and I'm just opening sir's slides.
Thank you so much, Hitesh Kumar. That's very generous introduction. I appreciate that. Thank you so much. Welcome to all of you. I'm 11 and a half hours behind you. And I hope you've had a stimulating and productive conference. And I hope to contribute to it in some small way. I want to begin by thanking Dean Ranita Nagar for her invitation to speak. She's always been so generous to me. And no matter how badly I speak, no matter how trivial the ideas I talk to you about, she always invites me to come back, for which I'm very, very grateful, because I love this subject and I love to talk with you about it. Let me give you a brief outline. I'm hoping to speak for no more than 35 minutes or so, to leave time for questions and your comments and observations. I'm going to first give you an idea about the origins of this title, Nudges and Mandates, Complements or Substitutes. I'll try to explain what a nudge is and why we might use it. I'll try to explain what a mandate is and when we might use that. And then I'm going to try to bring these two subjects together to talk about whether they are what an economist would refer to as complements, that is, like automobile tires and an automobile, things that are used together, or they're substitutes, like tea or coffee, and try to begin a discussion about how nudges and mandates ought to be fit into the general topic of how can we channel human behavior into socially desirable ends. So here are the origins and an overview. Let me begin with a very brief overview of behavioral economics. Behavioral economics, for which there have been 2 Nobel Prizes awarded, one in 2002 to Danny Kahneman and one in 2017 to Richard Thaler. Behavioral economics recognizes that most human beings are not the cold, calculating, self-interested people imagined in the phrase economic man. Human beings make mistakes. They are imperfectly rational. They get things wrong sometimes. And in devising public policy about economic matters, about legal issues, about financial regulation, everything ought to take account of the fact that we human beings are imperfectly rational and may not behave in the way that the traditional theory of economic man or woman says that we behave. I have found that there are great examples, some of which I'll try to point out to you. I mentioned some of them on the next slide, Hitesh Kumar, of examples of nudges that replace the standard economic way of dealing with things. I'll return to talk about those in just a minute, but let me give you one example. Many of us in the academy have boxes in our offices into which we throw used paper in the hope that whoever is going to clean up our offices, including us, will remember to put that paper in the recycling receptacle that our employers provide. But most of us keep that recycling box underneath our desk or beside our desk. It turns out that if you move the recycling box into the hallway where your colleagues can observe what you're doing and fill up that box out in the hallway, it serves as a signal to other people that they too should do a lot of recycling. And in fact, where boxes of recycled material are put in the hallway rather in a person's private office, that the amount of paper recycled increases by between 50 and 100%. It's a small change in how we do things, but has a very large payoff. The second thing that got me to thinking about nudges versus mandates is our recent experience in the United States and perhaps in India as well with the pandemic. How do we induce people to behave more safely so that they are protected against contracting the coronavirus and they are less likely to communicate that virus, if they should have it, to other people? For example, how do we convince people to wear masks? How do we convince people to get vaccinated against the coronavirus and to get boosted? I'm going to give you some data about the pandemic in just a moment to try to indicate to you that this is an extraordinarily productive area in which to think about nudges versus mandates. And I'm going to, at the end of the talk, give you some very preliminary ideas about when to use nudges with mandates and when to use nudges separately from mandates and perhaps in a sequential order. I think I'm on slide 4 now, Hitesh Kumar. Nudges were first championed, as you probably all know, by Richard Thaler, an economist at the University of Chicago, who won the Nobel Memorial Prize in Economic Sciences in 2017, and Cass Sunstein, who was at the time his colleague at the University of Chicago. Cass Sunstein is a remarkable scholar who now teaches at Harvard Law School. In 2008, they published a book called Nudge, Improving Decisions About Health, Wealth, and Happiness. And incidentally, late last year, they published Nudge, the final edition, which talks about some developments in the use of nudges that have arisen since their initial work. There are lots of definitions of a nudge. Here's one that I like. It's a gentle push designed to channel individual behavior in a particularly socially desirable direction. Some of the distinguishing characteristics of nudges are that they seek to preserve freedom of choice. They don't demand that somebody behave in a particular way. They just gently push them that way. Sometimes this method of influencing behavior is called libertarian paternalism. Some critics have said that that phrase, libertarian paternalism, is an oxymoron, that is a self-contradictory statement like military intelligence, which is, some people claim, a self-contradictory statement. Nudge stands in contrast to the standard economic tools of using price or cost to change and channel individual behavior. Let me give you an example. In the health category, some people have talked how to dissuade people from drinking sugary drinks, which are bad for your health. And some jurisdictions in the United States tried to impose a tax on sugary drinks as a way to raise the cost and cause people to consume less of it. That didn't work. It was annoying to people, and they kept drinking their sugary drinks even though they were more expensive. It was an inelastic demand, as economists would say. Another nudge that seems to have worked is requiring restaurants and the producers of goods that you buy in grocery stores to post the caloric intake or caloric content of the food you might consume in their restaurant. That turns out to have had a pretty dramatic effect on how much people eat and the kinds of food that they eat. Another set of examples from the literature that I've given you on the next slide are what are called automatic retirement savings. Richard Thaler and Shlomo Ben-Artzi published a famous article many years ago called Save More Tomorrow. Instead of simply encouraging employees to save more money for retirement, they suggested a program that automatically placed a significant percentage of any increase in wages or salary into a retirement fund. And because the default rule was that's going into your retirement, most people didn't touch it. And as a result, the amount of savings for retirement that people did increased significantly. Another great example of the effect of nudges has to do with organ transplantation. Fortunately, we've got some data from the real world about this matter. What should our policy be about encouraging people donating their organs for transplantation? As you probably know, there's a tremendous excess demand for human organs for transplantation into people who need those. And there are two general ways to encourage that donation. We could start from one of two default rules, an opt-in rule that says, yes, you can take my organs, but I can opt out if I want. The other is to start the other way around with a default rule that says, no, you cannot take my organs, but I can opt in. In the United States, our default rule in every state is an opt-out rule. No, you cannot take my organs, but I can change that rule simply by signing the back of my driver's license, for example. Happily for our studies about the effect of default rules, about 9 countries in the European Union of 27 countries begin with the default rule of an opt-in rule. That is, we're taking your organs unless you incur the cost of opting out. And what we find is that although, if you believe the Coase theorem, whether we start from a default of opt-in or default of opt-out shouldn't make any difference, it turns out that starting from a default rule of opt-in, that is, we're taking your organs, but you can opt out, that rule leads to a much higher level of organ transplantation donation than is the case with an opt-out rule. And I've already told you about the example of paper recycling in offices. There has, since 2008, when Thaler and Sunstein wrote their book, there has been a tremendously interesting policy response. In the United States, President Obama was so taken, he was a colleague at the University of Chicago Law School with Cass Sunstein, was so taken by the idea of nudges that he created something called the Behavioral Insights Team. that made recommendations to federal regulators about using nudges. This won't surprise anybody. As soon as President Trump, well, he's not president anymore, and I hate to use that term with him. As soon as Donald Trump was elected president, one of his first acts was to disband the Behavioral Insights team. I don't think he recognizes the difference between a nudge and a ham sandwich, but he thought it was a good idea to get rid of something that Obama thought was a good idea. It's one of the many idiotic things that the man did. In the United Kingdom, the government, doesn't matter whether it's Labor or Conservative, created a nudge unit to make recommendations to policymakers there about ways to increase things. For example, the nudge unit in the United Kingdom, also now disbanded, wanted to increase tax compliance, that is the number of taxes, the amount of taxes paid by physicians. And so they sent letters to every physician in the United Kingdom telling them how much of their income, generally speaking, was given in taxes compared to the doctors in their neighborhood. That, knowing how you are behaving relative to your peers, is an extraordinarily important matter for people to know about. And those gentle letters, gently pushing doctors to pay their fair share of taxes by telling them how they were doing by comparison to their neighboring physicians, led to a tremendous increase in tax compliance. Nudges are a great idea, but as the next slide will indicate, there have been some problems with nudges. Where nudges consist of just disclosing information, we know that disclosure doesn't really work very well. There's an extremely famous article by Omri Ben-Shahar and Carl Schneider called The Failure of Mandated Disclosure. I recommend this article to you extremely highly. They also wrote a book that elaborates on this idea, but the gist of it is they go through a lot of mandated disclosures and find that they don't work. They make the lawmakers think they've done something non-invasive and good just by telling people information. But it turns out that people don't pay a lot of attention to information dispensed by anybody, except those who give them information that confirms their pre-existing beliefs. That's known as the confirmation bias. And I'll talk about that again a little bit later. Another problem with nudges was indicated in this wonderful article by Professor Lauren Willis called When Nudges Fail, Slippery Defaults. As you know, I've mentioned this before, default rules are extremely powerful. We've seen that in the instance of organ donation for transplantation and automatic retirement savings. Lauren Willis applied this idea of the power of default rules to checking account overdraft fees. These are fees that banks charge if you write a check that is greater than the amount you have in your checking account. Half of all bank profits in the United States, and I suspect elsewhere, came from those checking account overdraft fees. It's a tremendously good example of the behavioral observation that people are over-optimistic. I won't need any protection against writing a check that's bigger than my checking account balance, because I won't do that. I'm responsible. I will not overdraw my checking account. But people did it all the time. And because the default rule was that the bank would cover your overdraft and then charge you a significant fee for having done so, half of all bank profits were generated by those fees on overdraft coverage. With the opt-out rule, we had an opt-out rule. You were going to be charged for that, regardless of what you thought. And then in 2010, the Federal Reserve Bank in the United States changed the default rule for overdraft protection to an opt-out rule. That you have to take steps to get out of it. And as Lauren Willis indicates on the next slide, it didn't work very well. And the reason it didn't work very well is instructive. Most people opted into the default, to the overdraft protection. Why? Because the people who stuck with the opt-out provision were precisely the ones least likely to need overdraft protection. They didn't overdraw their accounts. And secondly, and importantly, private banks were much closer to their customers than the Federal Reserve is. And those banks could influence their customers to opt in to overdraft protection, no matter what the default rule created by the Federal Reserve was. For example, every bank would offer you a free toaster or a free coffee maker if you'd sign up for getting overdraft protection. Finally, I wanted to mention a very important general criticism of nudges. It's not a criticism of the idea of nudges, but Ryan Bubb and Richard Pildes, who are professors at the New York University School of Law, in this famous article from 2014, How Behavioral Economics Trims Its Sails and Why, they criticize behavioral economics for creating a presumption in favor of nudges and against mandates. They say that we ought to be more even-handed and choose nudges if they're going to work and choose mandates instead if they're going to work. But we shouldn't just push mandates out of the picture. Let's keep that tool with us. Shortly after that article, Cass Sunstein replied to the Bubb and Pildes article in a short but very good article, Nudges versus Shoves, in the Harvard Law Review Forum, in which he made this very important point. Freedom of choice is a real value, and it's something people place a great deal of value on. And I'll come back to this later in a minute. Sunstein suggests that regulators should start their regulation from a belief that nudges are the preferred form of regulation, because nudges preserve that freedom of choice, and use an alternative to nudges, mandates, only if there is a compelling case to do so. Why? Well, Sunstein says, well, nudges are generally cheaper and they're self-enforcing. We just create an opt-out rule or an opt-in rule as the situation demands, and that usually does the work, except in the example cited by Professor Willis. Mandates, by contrast, are administratively complex and often very costly to run. Before I turn to the pandemic, on the next slide, let me make the case about mandates. Mandates are the standard pre-behavioral economics form of regulation. They are frequently referred to as command and control regulation. Examples are price controls, or forbidding people to do certain things like pollute, or commanding that those who are regulated, like banks, behave in a certain way. Command and control regulation very frequently has a regulatory agency with people appointed by political bodies and a staff and a set of statutes that enforce them, their power to mandate certain kinds of behavior that we believe are socially desirable. But mandates have their own problems. They're inflexible. You would think that there ought to be circumstances in which somebody says to a regulator, I know you want me to do this sort of thing, but it's not appropriate for me in my circumstances for the following reasons. Almost never can the subject of a mandatory regulation make that argument. Secondly, as I've just indicated, mandates have high administration costs. Thirdly, they usually require close monitoring of the behavior of those whom the mandate regulates. If you have pollution mandates, you have to have a method of determining where each possible polluter is above or below the mandatory level of pollution that you've established. And this is a very compelling argument these days, mandates interfere with personal freedoms. And to capture that, I'll repeat a phrase on the slide that one hears all the time these days: you can't tell me what to do. Well, if you're a parent and your child says that to you, you say, well, of course I can, I'm your parent. But if the government tells you you have to do this, you have to read this 500-page book by Leo Tolstoy for your education, your inclination is to say, I might want to, I might not want to, but you can't tell me what to do. It's an unfortunate circumstance, but mandates give rise to that. Now, let me talk about the pandemic and why this might be a good example of the choice between nudges and mandates. Since February 2019, when the Western world and most of the rest of the world discovered the coronavirus disease called COVID-19, more than 6 million people have died worldwide. Now, to put this in some context, in the great influenza epidemic of 1918 to 1921, also a 3-year pandemic, 50 million people died around the world in a much smaller world population. So although the death rates have been huge from SARS-CoV-2, they're not on the same order as they were in the great influenza epidemic of almost exactly 100 years ago. In the United States, almost 1 million people have died, 960,000 plus. We account for almost 1 in 6 of all coronavirus deaths in what is arguably the richest country in the world. There are approximately 40,000 new cases of COVID-19 every day in the United States. That's 2/3 lower than it was about a month ago when the Omicron variant was spreading. But there's still 1,300 deaths per day as of just 2 days ago. Now, that might not sound like a lot, but that means almost 10,000 deaths per week or 40,000 deaths per month. That means we're going to get to 1 million deaths within the next month in the United States. We haven't had anything remotely like this for over 100 years. Here's a very important point I want to come back to. Between 95 and 99% of all deaths from the coronavirus since February 2019 have been among the unvaccinated. Now, that's a bit misleading because there was no vaccine available until January of 2021. The slide says since spring 2020, it wasn't. It was only available in January of 2021. Next slide, please, Hitesh Kumar. How do nudges and mandates apply to the pandemic and trying to minimize the health consequences of exposure to SARS-CoV-2? Well, the two episodes of regulation that I want to point to are mask wearing and vaccination. Let me first say a few words about mask wearing. If we're going to nudge people to wear masks, we should make it easy for them to do so. We should disclose the benefits, make masks readily available for free, and correct any misunderstandings people have about the benefits of wearing information. The unfortunate thing in the United States about mask wearing was that mandates became politicized very quickly in the United States. If you haven't seen it, I urge you to go to YouTube and look for a very short video in which the governor of Florida, Ron DeSantis, says some very unkind things to some teenagers, some young people, before whom he is about to give a talk. He says to those young people, quit wearing those masks. That's just political theater. He's suggesting it doesn't have any substantial effect. You're just trying to create a political effect. Now, the amazing thing about this is Governor DeSantis ought to know better than that. He's a graduate of Harvard College and of the Yale Law School. And the unkind things that he said to these young teenagers who are trying to protect themselves and other people by wearing masks really are uncalled for. It's an unfortunate thing. I have seen the effects of mandates on mask wearing in the United States in my capacity as a volunteer member of the governing board of the Champaign Public Library. We have about 3,500 visitors every day to the Champaign Public Library. It's a marvelous place. And beginning in mid-2019 and for about a year and a half, we had a mask mandate. If anybody came into the library, they had to wear a mask. If they didn't have a mask, we gave them a mask. What happened was that we had fights with some people who came into the library. They said, I'm not going to wear a mask. And we said, well, then you'll have to leave. And then those people and the staff at the library got into shouting matches. We had to call the police to take people out of the library. The director of the library finally said, I'm not going to get involved in this anymore. If people want to wear a mask, I'll let them wear a mask. If they don't want to wear a mask, I'll suggest they do, but then let them go if they don't want to wear a mask. Now, the evidence is that wearing a mask was a very effective and inexpensive way of protecting the health of both the mask wearer and the people with whom he or she interacted. One dramatic piece of evidence we have is that during the winters of 2019 to 2020 and 2020 to 2021, the incidence of flu was about 1/10 of what it had been in the years before we were wearing masks to protect against the coronavirus. It also gave us protection against flu. Well, I want to turn in the next couple of slides to, and I'm about 3/4 of the way through my talk. I want to turn to vaccinations. We have had, since January 2021, 3 generally effective vaccines available. And since the fall of of 2021, not 2022, we've had boosters available for those who would like to get them. As of 2 days ago, about 65.2% of the US population above 5 years old has been fully vaccinated. That's not as high as we had hoped. As of the same date, about 76.6% has had at least 1 dose. 2 of the 3 vaccines require you to have 2 doses. So about 77% have gotten at least 1 dose, which provides some protection, but not as much as if you get the second shot and a booster. The federal government had a goal of having 80% of the United States population fully vaccinated, that is 2 doses plus a booster. Now I want to talk about some characteristics of those who are vaccinated. The fully vaccinated rates differ significantly by age. The group with the highest rate are those 65 to 74, 91.2%. The next highest rate is among those over the age of 75, 85.9%. For other age groups, younger age people, the rates are much, much lower. What about the rates of being boosted? That is, having a third shot that's about half as strong as the first 2 doses. Only 44% of those who are fully vaccinated have gotten a booster shot. These vaccinations do not provide protection against contracting the Omicron variant. but the severity of the case is much, much lower. Death rates among those who are fully vaccinated and boosted are about 1/20 of the death rates among the unvaccinated. My wife and I both got coronavirus in January, and it was not pleasant, but it wasn't horrific, and it was over pretty quickly. Here's my wife is in the background and says, no, that's not true. The rates of vaccination, here's what I'm about to tell you is to me the most fascinating things about nudges versus mandates. The rates of vaccination differ dramatically by geography in the United States. The northeastern portion of the United States and the middle Atlantic states, that is, as you're looking at the map, everything from Washington, D.C. up to the top northeast corner, the state of Maine, those are the most highly vaccinated portion of the country. Why? The next highest rate are the Midwestern states, the so-called upper Midwest, Illinois, Wisconsin, Minnesota, Iowa, Michigan, the great center of the United States. There are similarly high rates along the West Coast, Washington, Oregon, and California. In the Rocky Mountain region, between the Midwest and the West Coast, Colorado and New Mexico are also highly vaccinated, but the rest of the mountain states are not. Florida is the only state in the southern portion of the United States that has a high vaccination rate. And they have a high vaccination rate because they have a high concentration of older people. And as I just mentioned, older people are far more likely to get vaccinated than other people are. Now, the states with the lowest vaccination rates are clustered in the South, the mountain states such as Montana, Wyoming, and Idaho, and North and South Dakota. Why should there be this difference? Why isn't vaccination constant across all 50 states in the United States? Well, as you can imagine, economists and some lawyers and a lot of public health officials have studied these figures. And by the way, I didn't say this, but I should have. Vaccinations are free. They don't cost you anything out of your pocket. They're widely available. Any grocery store, any drugstore in the United States will give you shots for free. So the nudge to get vaccinated is gentle but widespread. The curious thing about these geographic differences is that there's a very high correlation between the rate of vaccination in the state and the percentage of its adults who voted for President Biden rather than Donald J. Trump. Higher vaccination rates are associated very strongly at 0.9 level with higher percentage voting for President Biden. Higher vaccination rates are associated with low votes for Donald J. Trump. By contrast, lower vaccination rates are associated at a 0.95% level with a lower percentage for Biden and a higher percentage rate of voting for Donald J. Trump. That's at the state level. If we go down to the county level, and every state has counties, for example, Illinois has 102 counties. If we go to the county level, the correlation between vaccination rates and presidential choices is even stronger. Why in heaven's name should that have anything to do with the decision to get vaccinated? Well, here are a couple of thoughts that I've had about this. Because 99 to 95% of those who have died from COVID since vaccines became available in January 2021, 95 to 99% of those who have died were unvaccinated. They were much more likely to have voted for Donald J. Trump. Because those states that voted for Donald Trump are called red states, the states that voted for Biden are called blue states, some people are now calling this red COVID because it strikes people who voted for Donald J. Trump. And that's who it's killing. Almost 1 million people have died from this, and the vast majority of them were supporters of Donald J. Trump. Why there should be a political connection, I don't know. Why did this politicization begin? Well, it's not a case of nudges versus mandates. I'm sorry, I put nudges versus vaccine. It's nudges versus mandates, because everybody had the vaccine available for free. There wasn't a mandate. Was it based on something else? What is it? Was vaccines skepticism greater among the supporters of Donald Trump than Biden? Apparently so, but why should that be the case? I can tell you this personal story. The woman who used to cut my hair told me 6 months ago that she and her husband and her children were not vaccinated. And I said, why not? And she said, because the evidence is not compelling. And I said, what do you mean? And she said, well, the vaccines haven't been tested. And I couldn't resist being a professor. I said, well, that's not true. The Food and Drug Administration requires that there be 3 phases of testing for any drug that's going to be offered to the population. And every one of these vaccines has been through those 3 testing phases, and they were found to be safe and effective. And she said, that's not what I hear. And I said, well, it's what I hear. And it's what I just told you. And she said, that's not what my friends said. Well, somebody else is cutting my hair now. So what is this skepticism correlated with? I'll give you a suggestion in just a second, but it shouldn't be correlated with Trump and Biden. The administration of Trump should get, there are not many things I would praise the Trump administration for, but one thing I would praise them for is that they did a marvelous job of encouraging people, of encouraging the development of the vaccines. They don't get enough credit for that. And in fact, on the next slide, I point out that when Trump tells his audiences today that they should get vaccinated, they boo him. That must be a shock to him, but he gets booed by his own loyal supporters. I'm not sure why we have this vaccine skepticism, but some political scientists have said that the difference between Biden and Trump is really not a difference between Democrats and Republicans. It's a difference between levels of education. The greater the level of education in a state, county, or city, the greater the percentage of the population that's vaccinated. That, many political scientists tell us, is really the thing. How do we persuade people who are skeptical of the value of vaccines to get vaccinated? By nudging them or mandating it? We've tried nudging, it doesn't work so well. Now we've tried mandates. The Biden administration issued 2 mandates last fall. One through the occupational, next slide, please, Hitesh Kumar, through the Occupational Safety and Health Administration, known as OSHA. In fall 2021, OSHA mandated vaccination for all employees of firms with 100 or more employees. That would affect 80 million workers. Secondly, in the same attempt to shift to mandates, the Biden administration in fall 2021 asked the Centers for Medicare and Medicaid Services, known as CMS, to mandate vaccines for all employees of healthcare facilities that receive Medicare or Medicaid funding from the federal government. That would affect 76,000 healthcare facilities in the United States, almost all healthcare facilities. In January 2022, the United States Supreme Court decided 2 cases about these mandates. In the first instance, the OSHA mandate that would have affected 80 million workers, the Supreme Court said No, you can't do that. You cannot use OSHA to mandate that people get vaccines in order to continue to work. They created something called the big question doctrine. If an administrative agency appears to be going beyond its mandate from the government to pay attention to a particular area, that question should be taken up by the entire Congress, not by the administrative agency. So the Supreme Court was saying, OSHA, you can't do this, but if Congress wants to do it, they can do it. But in the second set of mandates, Biden v. Missouri and Becerra v. Louisiana, the court decided by a 5-4 majority to allow the Centers for Medicare and Medicaid Services to mandate that healthcare workers be vaccinated as a condition of employment at Medicare and Medicaid funded facilities. That's one of those things that makes people who follow the law think, what's going on? Okay, I'm not, in the interest of time, I'm just going to raise this issue. How do people decide whether to get vaccinated? What information do they use? As you know, my hairdresser used some information that I don't know anything about, and she was not open to using the evidence that I gave her. Why? How do you trust experts? Do you trust your friends? Do you seek out the information? And are you prepared to change your behavior in response to the information that you discover? Do you use well-trusted sources of news information to make your decision? Or do you use extreme, on the left or the right, extreme sources to get your information? I think there's one piece of information that should have persuaded everybody to get vaccinated, and that's the fact that between 95 and 99% of those who have died from coronavirus, almost 1 million people, were unvaccinated. I don't know what else you need to know, but apparently that's not enough. Okay, final slide, and then I'll stop, I promise. These are some very preliminary thoughts on whether nudges and mandates are complements or substitutes. I like Professor Sunstein's presumption in favor of nudges, but I think he needs to be more explicit about the provision he imposes, that the choice between a nudge or a mandate be made in favor of a nudge if they are roughly equally effective. They're substitutes in some circumstances, and you should go with the one that's more effective at the same cost, or the one that's cheaper but about as effective. When there are significant differences in the costs and benefits, there may have to be trade-offs that our public health officials make, and they ought to be explicit about, at that point, how they made the trade-off between a nudge and a mandate. I would also point out in conclusion that sometimes nudges and mandates can be complements. If we can identify geographically where nudges are going to be effective and where mandates are necessary, we can use different tools in different places. In university towns and in the north, as you look at it, the northeastern portion of the United States, and on the West Coast, people responded to the nudges to get vaccinated. In the South, people didn't respond to the nudges and they hated the mandates. You can't tell me what to do, is what they said. If I don't want to get vaccinated, that's my business. Keeping those two tools for different geographic areas is a possibility. I don't think it's very likely, but it's certainly a possibility. By age categories, the older appear to respond more to nudges than the younger do. So maybe we ought to, if we could, differentiate to whom we are directing our nudge, or the audiences that we're trying to mandate to do something that we deem to be socially desirable. Older people, I'm now a representative of that group, older people appear to behave far more sensibly than other people. That's not a surprise to me. I'm kidding, of course. Another thing that we have apparently tried that doesn't work very well is to use nudges and mandates sequentially. Let's start with nudges and see what effect we get. And if it's not the desired result, then let's switch to mandates. We've tried that. It doesn't work particularly well, but those are my preliminary thoughts. Thank you all for indulging me, for listening to me. I always appreciate any audience that I can speak to, and I'd be happy to answer any questions that you might have. I'm sorry that I went on so long. I didn't think I would, but I think professors speak in 50-minute increments.
Floor is open for question, comments, if you can put in the chat section.
Professor Woolen, we have Tom Ginsberg also with us.
Kidding. Hi,
Hello.
Tom.
In fact, I have a question, if I can ask a question of Professor Yulin.
Oh, how delightful. That's
Yes,
one
sir,
of
go
my
ahead,
favorite
sir.
professors.
So you're talking about the law in economics here, and I think your discussion of nudges and mandates is really interesting. There's another law in econ literature which may be relevant to this, which has to do with impersonal trust, the game theory development of impersonal trust.
Yeah.
And one explanation for the phenomenon you have identified is that there's regional variation with regard to trust, and that's changed over time. It's broken down in society.
Yeah.
Have you thought about, is there a kind of game theory explanation for why we would observe the decline in trust in societies?
That's a great question, which is exactly what I'd expect from my dear former colleague. I haven't thought about that, but it's a terrific thought. I assume you know better than I that there's a vigorous literature in the political science area about the alterations in impersonal trust. Is that true? Is there, and do you have any idea, what does that literature tell us about changes over time in impersonal trust and geographical variation and correlation with other factors?
I don't know it well, but in the United States, you can tell a story about the financial crisis and the Iraq invasion, but I don't know if that's sufficient, because we also see this in many other societies, and so it's a mystery to me a little bit.
Yeah. Well, the only I won't take much of the audience's time by saying I don't know much about this, but I do know that that's a very strong suggestion, and it's one that may help us try to explain where nudges are going to work and where they're not going to work. I'm just speculating here that we're in interpersonal trust is at a low. Nudges are unlikely to work, as well as they work where there is a higher level of interpersonal trust. You're right that part of the politicization of all of this has to do with your attitude about the federal government generally and the particular people who are in charge of the federal government. I still am puzzled by why that leads people, why that information trumps the information about the relationship between being vaccinated and not dying from contracting the COVID. I don't know anybody in this town, but of course it's loaded with people who went to a very good university, as is your place. I don't know why that just doesn't end the argument. That just, on a risk basis, why that information doesn't trump anything else. I don't like to use the word Trump in that regard, but there you have it. But it's a great thing. It's a great suggestion, Tom. Interpersonal trust is at the lowest level I think it's probably ever been in our history. And many commentators, I just finished a wonderful book by Michael Sandel called The Tyranny of Merit, which I commend to everybody, suggesting that interpersonal trust, we've gone far too far, he says, in focusing on individual choice, and have lost sight of the community in which we live, and that we're part of a society. and the sum of our individual things must give way to societal concerns. Great question.
One question, two great professors. One question, I'm braving to pose it. Could it be economic crisis, regimentation of thought, and the question of this losing trust, this entire interpersonal trust? So economic crisis, regimentation, moving away from a objective scientific outlook, and this cracks in interpersonal trust. I don't know. It's a big question posed.
It's a good question. Tom, do you want to say something about it, or should I try? I think it's a really good question, and it gets at the same thing, Renita, that Tom just raised. We know that on objective grounds, interpersonal trust, and this is an important element, trust in the opinions of experts has gone way, way down in the United States. Because I sometimes try to dispense information as if I were an expert, I'm distressed by this, but I'm distressed by observing this phenomenon that you may not have known about. The director of the National Institutes of Health agency that deals with infectious diseases is a remarkable man named Dr. Anthony Fauci. He's served every administration since the 1970s. He's a very distinguished scholar. He's a cautious, middle-of-the-road man. He has become demonized by the people who don't like mandates. And that should never happen. It's one thing to say, I disagree with these because, and give a good reason. It's another for people to make threats. People are making threats against Dr. Fauci's well-being and against his family. He's been given the protection of the United States Marshal Services to protect them against these. Why would you just, I can understand disagreeing with an expert for a good reason, but I cannot imagine that the degree of interpersonal trust for experts has sunk so low that people threaten the lives of one of our leading public health experts in the United States. And that's only an example. My hairdresser thinks she's paying attention to somebody who's told her something objectively true. I told her it wasn't. She didn't believe me. My truth is not your truth. The evidence that you look at is not my evidence. How can it be? As the great Senator Daniel Patrick Moynihan, a former academic at Harvard, said, you're all entitled to your own opinion, but you're not entitled to your own facts. But we can't even agree about that.
There's a kind of, in the circles of politics, the ends come together. I sometimes say the Republicans are like the postmodernists. There's no real truth. It's not right to believe that Obama was born, is from Mars or something like that. And you can't tell me that it's not. But in terms of Renita's question, I think one interesting fact is that we observe this set of beliefs without really regard to income. So even though there's economic crisis, I think that Trump voters, were wealthier on average than Biden voters on average. So it's kind of interesting. It doesn't, Marx was wrong, right? It's not simply reflecting, people's class interests in some sense. It's something else. It's ideology and a strange collapse of the former belief systems.
Yeah.
Can I conclude the session though, so we can start with the new? Respected Ulan sir, I think you have already you discussed a mandate versus nudge, and I think you made a clear point that that there may be both angle, maybe complementariness, maybe there, or substitution, maybe there. And the proposal of not only vaccine, but the proposal of seeing the nudge in the context of overall the pandemic and overall the crisis. But for only for the lighter side, take it in a humor that like GNLU Center for Law and Economics started working in law and economics, where initially even I have not heard about this subject called law and economics, even in my PG and when I joined the academics. So it was either mandate, it was either a nudge, but clearly in the 10-year timeline, we found that because of grace of you, Ginsberg sir, Kutta sir, and many other the scholar, even in India, Ram Singh sir, Prasad sir, Malin sir. If I name, I think many people will come. I think nudge was created, and I think somehow, somewhere, it is not any mandate anybody can give. You said you can't direct anybody to do what, but I think it was inside willingness. Some of the behavioral changes happen, and currently the center is leading, and center is one of the center which is working in the area of law and economics in India, and it is one of the promoted centers because of the nudge of what you people have done, and I think we are in the right track. With that, I would like to conclude this session, and with permission of Madam, I want to put forth the forthcoming book, which is the previous year conference, the fourth edition, which we have organized. I think that is under the publication. It may take 4-5 months, but we do have cover page. So with the permission of all of you, I would like to put poster here. Sorry, I'm just doing 1 minute, some technical glitch.
Oh,
I hope. So this is under the publication. Hopefully within a 4-5 months, it may come, and we are thankful to one and all who has guided us in the path of law and economics, and we are very much thankful to Professor Roland sir for contributing the forward for the book. And thank you for all blessing and that. If Madam want to say something, please.
I have nothing to say other than a unending round of gratitude to one and all, especially for the experts present here. What can I say? I wake up Professor Ulan so early in the morning, don't let him sleep. He says yes. Ginsberg sir, he has such a busy schedule. He tells me not possible. Somehow he still manages to, carve some time for us. That's Professor Ginsberg. So, I mean, what else can I say? And you, Dr. Thakkar, that you have, brought in good publications, in Scopus and Web of Science. In the area of law and economics, that's a huge education. I mean, someone was saying that we didn't know this 10 years back, and today we are there and doing well. It's been such a journey, and I just have a lot of gratitude for everybody. That's all.
thank you. Thank you, Tom. Wonderful to see you. Thank you, Hitesh. Thank you, Renita.
Professor Ulan, I didn't know about your ill health. I hope you are better and okay and recovered.
We're fully recovered. My wife says not, but oh, you don't agree? Yeah, she's fully recovered, she says, and I'm fully recovered. I had 2 or 3 bad days, but didn't have to go to the hospital. I just called my doctor, and he arranged for me to get something called monoclonal antibodies. I don't know what those are, but they worked.
So that was in January, no?
Yeah, yeah. We were tired for 2 or 3 weeks, 4 weeks afterwards, more tired than normal. But otherwise, I could still carry on.
I'm glad you're better, and please, our best wishes to Madam that she recovers completely and she's all right.
Thank you.
On that note, thank you so much, Professor. We'll have to conclude. Thank you.
Hi to Amber, Tom.
Thank you, one and all.
So much.
Thank you.
I-
Sir.
Thanks, Hitesh Kumar.
Kusi, if you can introduce Nalin sir and the next session, if you can go ahead.
Yes, definitely. Thank you, sir. A very good evening to all the respected speakers, attendees, and members of the organization committee. On behalf of the GNLU Center for Law and Economics, I extend a very warm welcome to plenary session 4 and the last plenary session of the 5th International Conference of Law, Economics, and Public Policy. I would also like to extend a very warm welcome to our speaker today, Professor Tom Ginsberg, the Leo Spitz Professor of International Law and a professor of political science at the University of Chicago Law School. Dr. Ginsberg focuses on comparative and international law from a very interdisciplinary perspective. A part of the incredible Comparative Constitutions project, Dr. Ginsberg has gathered and analyzed constitutions of all independent nations since 1789, and he continues to work with numerous international development agencies and foreign governments, all while contributing immensely to the field of law and economics. We are extremely glad to have you here with us today, sir. And before we move forward, I'm also very glad to introduce our faculty moderator for today, Professor Nalin Bharti. Dr. Bharti is a professor of the Indian Institute of Technology at Patna with immense research experience in the field of macroeconomic reforms, labor economics, WTO, and India, being part of the Finance Commission for the Government of India and various other federations and research institutes throughout the country. He has contributed immensely to the field of economics. We are very glad to have you today with us, sir, and I call upon you to take over the reins of moderating this session. Thank you.
Yeah, thank you very much. Let me first welcome Professor Tom Ginsberg for this special talk, and this will be the last talk of this 2 days conference. But before that, let me also set the tone for this special lecture. When we see the COVID-related data, because the lecture is on Constitution and COVID, so let me bring some data, and this is the data till last evening, which is available with the WHO in terms of COVID infection. So globally, around by 5 p.m. yesterday, around 4 crore 50 lakhs, 45 crores, 50 lakhs COVID infection, and around 60 lakhs, 19,085 deaths in the world. If you see alone the infection, total infection in United States, that is above 18 crore, and total infection in Europe, total infection in Europe, that is around 14 crore. So India alone has around 4 crore 29 lakhs 80,000 infection, COVID infection cases till yesterday. So this has a huge implications for the state. And before COVID-19, there were 2 cases in which in India, the Supreme Court of India, especially given the judgment, one of the cases Permanent Katra versus Union of India, in which the Article 21 was well cited, and it was argued that the concept of healthcare was added as an integral part with this judgment. And before, at that time only, there was another judgment after few years, and this is Paschim Bengal Khet Mazdoor Samiti versus Union of India, in that case, also the Supreme Court of India has clearly mentioned that the primary duty of the government to provide adequate medical facilities to the people. COVID-19 was one of the testing time, not only in India, but in other part of the world also. So the Article 21 of the Indian Constitution is clearly mentioning about the protecting the health of the people with lots of care and providing the freedom in terms of adequate life and a healthy life. So with this background, when the world is not free from the COVID-19 and the state is not even free from the next challenge, and that challenge is somehow reflected in the previous lecture also, where the new challenge is to have the universal vaccination for the people. So the neighboring country like Afghanistan had hardly 10% vaccination today. And African nations are again one of the very low ranker performer in terms of vaccinated people. So we have one side we have the country with a booster dose, and another side we have the large number of people without a single dose. So with two adverse, and we can say when the world population is completely having two opposite conditions, today's lecture by Tom Ginsberg is very important because he is directly discussing the relationship between the Constitution and COVID-19. So over to you, Professor Ginsberg, and I again welcome you for this very, very interesting lecture. Thank you.
Thank you so much, Professor Bharti, as well as Professor Renita Nagar for inviting me, and Hitesh Kumar, old friends. Very nice to see you. And I was thinking about Hitesh Kumar's comment at the end about, was it a nudge or a mandate that got law and economics started? And I think it was Dr. Nagar, who's a force of nature. And so she used both nudges and mandates and has really created something. So I'm very happy to be here with you. I'm going to share my screen here. Let's see if I can successfully do it. And yes, so what I am interested in is how constitutional law and public law have responded to this situation which every country is facing, what one does. And in some sense, it raises a very old problem in constitutional design going back all the way to the Romans, and that is the problem of emergency. We have our human rights, we can move around, we can engage in things freely, but we know that from a very old time, constitutional thinkers have recognized that there are some times in which the normal rules have to be set aside because of a crisis. And that if we were to govern using our normal rules, they might actually make things worse, not better. The Romans were the first to develop this, and we still use much of their framework today. They had this idea that they called the dictatorship. And of course, dictatorship now is an insult. It's a bad name. But their idea was really about exceptional powers bounded by law. Excuse me. So the thought was that when there was a crisis that was going to threaten the city, an invasion or something like that, they would have to have a special set of rules. And what they would do is they would, the Senate of Rome would say, there's an emergency, we need to appoint a dictator. And that dictator was appointed for a limited period of time, 6 months typically. And during that time, he was given all power. So he could do anything to save the city from the emergency. The only rule about it, the only constraint was that there was limited time period. So when the emergency ended, or a maximum of 6 months, that person had to leave. And usually it would be a retired general, for example, who would come in and save the city. And this was not a rare thing in Rome. Indeed, this institution was used 200 and something times during the Roman Republic and Empire. And normally, of course, we would think that that would be a great danger. How could you give someone all power? The risk would be that that person would take over the whole system. And yet that didn't seem to happen to the Romans. They did give these men all power for a limited time, and none of them ever took over. So that's very interesting. They had constitutional rules, and that's really why this connects so much with constitutions. First of all, you could only invoke the emergency when it was necessary, truly necessary. There was the limit of time, as I've mentioned. And then, interestingly, they separated what I would say is the epistemic function from the executive function. That is, the body which determined the emergency, which was the Senate, was different from the one that exercised power during the emergency. And from a law and economics perspective, this addresses the problem of moral hazard, right? That if we allowed one person to say, yes, there's emergency and I now get all power, then there'd be a moral hazard. You'd have too many emergencies. So by separating the invoker of the emergency from the actor, from the executive, that meant that you would really only get these in limited and genuinely necessary circumstances. This idea has carried forward today to constitutional design, and many constitutions have emergency rules. Political theorists in the West have debated about the question of whether or not law can really constrain emergency power. Machiavelli, the Italian political theorist, said yes, and thus he argued that constitutions should have special rules for emergencies that included these Roman principles. But there were other thinkers, and I'm thinking of John Locke, a British liberal theorist, who said, there's just some point at which the rules run out. There's got to be some sovereign power at the end of the system, which is truly unconstrained, the sovereign prerogative is how the British called it. And so there's kind of a debate in political theory about whether emergency powers can really be constrained, whether moral hazard can be addressed. This is carried forward to our era, and we see essentially two approaches. The book on the right is by one of my colleagues, Eric Posner, and a Harvard law professor, Adrian Vermeule. And during the early 2000s, they wrote this book. In the early 2000s, there was a lot of literature, a lot of writing about emergency power. Because, of course, the September 11th emergency, the war on terror, financial crisis. And they wrote a book that said, basically, in modern government, the executive is very powerful, and the executive cannot be constrained. There's some limit at which the executive just has to make the choices and the decisions, because the executive is the body with speed, with more information, and we can't help it. We're going to have to give power to the executive. And this, in a way, is John Locke's point. There's some kind of old idea that you just can't limit these powers by law. Against that, of course, are the constitutional provisions, which we see in many countries, which say, no, actually, we can limit those powers by law. You have to have requirements of strictly necessary measures, limited time, non-discriminate application. That means when you have an emergency rule that says, okay, we're going to confine everyone to their homes, you can't say, oh, it's only this caste of people that has a forced to stay home, or this race or this gender. You have non-discrimination measures. And finally, judicial oversight. That is the idea that when the executive says there's an emergency, that could be reviewed by courts. So that's interesting, that the measures are subject to law. So you can see this old idea about law, can emergency powers be constrained or not, carries forward to our current era. In the Western political theory literature, there is a figure who stands with the Posner theory and the John Locke theory, and that is the man named Carl Schmitt. He's the man in the left picture wearing the suit. And he is with some Nazi general. He was known as the political theorist for the Nazis, so he gets a bad name. But his theory is a very powerful one, and we still read it today. And his basic idea is that in any kind of system, there is some actor, a sovereign, who decides when the exceptional rules apply, when to set aside normal governance. And that person cannot be constrained. So the idea comes forward. The man on the right is the Prime Minister of Hungary, Viktor Orban. And he, during the coronavirus pandemic, got his legislature to pass a law which said all normal legislation is suspended. The Prime Minister can govern by decree. He can do whatever he wants, and notwithstanding normal law. And the courts can't review it. In a way, that's a move of a dictator, right? And Prime Minister Orban is especially concerned with maintaining his hold on power. He's up for a re-election in April, so we're going to have a very important election in Hungary. But in a way, he was using the Constitution of Hungary, which he basically wrote, to collect power during the COVID pandemic. And this is the fear that somehow emergency rule during COVID would be abused. Well, as I said before, the debate is addressed to some degree by post-war constitutions, which do provide for emergency rule. The figure on the right shows you the percentage of constitutions since 1800 that have provisions for emergencies. And you can see that at the very beginning, like the United States Constitution doesn't say anything about them. But over time, we see more and more countries, and especially after World War II, it became a standard feature of constitutional design to talk about what would happen in an emergency. Constitutions will list what kinds of conditions can give rise to emergency rule. War is the most common, and of course, we're now in a time of war in the Ukraine, so they will have to grapple with this. Internal security. Natural disasters are mentioned, but it's interesting. When I look at these provisions, I see very few discussions of financial crises or epidemics. And you might think that those are actually the most common emergencies for our time. After all, notwithstanding the Ukraine, war is not usually very common. But financial crises happen with some regularity, and now we must deal with epidemics. That means that maybe the Constitution didn't think about the COVID problem. The constitutions also require that any measures, emergency measures, be taken by law. So they say that law can constrain. They will also say that certain rights cannot be derogated from. Pardon me, but there's something in my throat. Certain rights cannot be limited. So even during an emergency, you can't torture people. Usually they will say the courts should remain open. And some things which even an emergency can't suspend. But in the COVID restrictions, we've seen amazing, reduction in rights. Of course, famously in India, essentially shutting all public places and restricting the freedom of assembly, freedoms of movement, some freedoms of religion, etc. So some rights have been restricted, but others could not. You couldn't torture, for example. Temporal limits. And finally, the idea that if the time runs out for the emergency, there should be oversight. That is, after the period of 6 months or however long the emergency is declared, it must be reauthorized by the legislature. So in other words, post-war constitutions believe that there can be legal constraints, and so does the international human rights system. This is the provision from the International Covenant of Civil and Political Rights, which basically requires that emergencies be publicly proclaimed, that in that circumstance, a state can restrict rights, but it has to do so by derogating, which means basically filing a notice that says we're not going to have freedom of assembly, or some such right, and say which rights are not going to be applied during the emergency, not going to be protected. Those restrictions on rights can only be those strictly required and cannot discriminate. So that's a kind of set of legal constraints which the world has come up with. Let's talk about COVID. Unprecedented, and we saw many situations in which, when the COVID pandemic hit, the legislation was not in place to deal with it. And that means, like Carl Schmitt, there were examples in which the law ran out and the measures that were necessary weren't actually legally authorized because no one had thought about it. I mentioned that constitutions didn't talk about pandemics. In some countries, they didn't have the legal authority to do what was necessary. Taiwan is a very interesting example. You know, in the first year of COVID, I think they had only 7 deaths in a country of 23 million people, an island of 23 million people. That's an incredibly small number. It would have been about 100 in the United States instead of several hundred thousand. They are an island, and that helped. And what the government did, as soon as COVID arose, they said, we're going to restrict travel. We're going to prevent large gatherings. And they did many things, but some of those things were not legally allowed. And so what they did is they went to the legislature and got a statute passed that was retroactive. It only took about a week, and there was public deliberation. It was a democratic process. But I guess my point is that from a strict rule of law perspective, they did violate it. In Italy, some of the early rights restrictions were done by decree rather than law, which is what the Italian Constitution required. And Ghana had the same. So in the very first days of the pandemic, when the crisis first hit, the law did run out. And that leads to the question of whether or not this led to sort of executive takeover. And here, my colleague and I, in this article, looked at every country we could find in the first 6 months or year of the pandemic. And what we looked for was who led the response. Was it the executive alone, or was it also involving the other branches of government? Was there judicial oversight? Was there legislative involvement? And what we found was remarkable. We found in most countries, democracies and even some non-democracies, courts were very involved in the coronavirus response, in calibrating between the measures necessary to protect public health and individual freedoms. What kinds of things did courts do? In Israel, for example, they made sure that the government followed the procedures which were required. So in Israel, they declared a lockdown without legislative approval. And the prime minister said, well, we can't have the legislature meet, it's too dangerous. And the court said, no, you can't do that. You're going to have to follow the rules. Actually, I think it involves cell phone tracing. In Israel, they face a lot of terrorist threats. And so they did have the ability in law to trace people's cell phones. But it was only in the case of terrorist threat, not in the case of public health emergency. And so the court said, you have to go and get legislature to authorize public health kind of exception. In Germany, many cases about the proportionality of lockdown procedures. In Malawi, a very interesting case, there was a leader who had won a kind of contested election. And the courts had said, you have to have a new election because there were too many irregularities. And that happened before COVID. Then COVID hit, and the president said, we're going to have to suspend that election. And the court said, no. You have to have that election. Not only do you have to have that election, you cannot have a lockdown. Because if you have a lockdown, people won't be able to organize and mobilize for the election. So in some sense, they put democracy above the public health, and it worked out. They had an election, they kicked that guy out of office, and the court saved the democracy from someone trying to abuse it for his self-interest. Lesotho was a similar kind of situation. Another issue that arose in some African countries was the use of force with regard to enforcing lockdowns. There was a time in Kenya when more people had been killed by the police enforcing lockdowns than by COVID, because the police were so strict. And the court got involved in limiting the police in that country. And finally, in India, and as well as Brazil, we saw something very interesting, which is the court demanding that the state take action when the prime ministers didn't want to. The president of Brazil didn't want to. The president of Brazil is a COVID denier. As you know, Prime Minister Modi has changed his views over time, but there was a time when he didn't want to take action. The Supreme Court said, no, you've got to do something. So that's a very interesting thing, which says to me that it's not just about the executive. The courts are involved in modern government. It's a kind of dialogue. Similarly, the legislature. The United Kingdom Coronavirus Act was a model statute for many countries. Basically, they recognized that to deal with COVID, many statutes had to be changed. The Public Health Act, the Education Bill, many other things. And what it said, what the United Kingdom bill did, is it addressed many areas of law and said all of these restrictions will end automatically when the pandemic is over. And that's a good way of making sure that the emergency provisions don't become permanent, don't end up leading to abuse of the government. I mentioned the Taiwan Act, which was a very good act. In Bolivia, the president wanted to suspend the election, and the legislature said, no, you can't do that. So we've seen a lot of legislative action too during COVID, which is somewhat of a surprise, given the kind of belief that my colleague had about executive power running everything. The United States is kind of a difficult circumstance, as Professor Yulin was talking about. We don't have any rules about emergency in the Constitution. And there are some statutes at the national level, but the main exercisers of emergency power are state governors who have very much power. They can do all kinds of things under the statutes during an emergency. But what we have observed is a kind of dialogue, political dialogue. And this, I think, gets to some of the law and economics of constitutions, where public policy is determined by a dialogue among the different branches. And you can imagine modeling the preferences and the negotiation back and forth in a game theoretic way, where the response is determined by the three branches of government moving in sequence in order to produce a collective response where none can determine it on their own. The courts, including the Supreme Court, limited many of the steps that some of the governors were taking, but in other cases they allowed them. So in an early case, one of the governors said, blocked movement from one state to another. So we're not going to let any cars come in from New York to Connecticut. And of course, no, you can't do that. That's discriminatory. In the case of Catholic Church v. Cuomo in New York, the court struck a provision which prevented religious groups from gathering on the basis that they didn't treat non-religious activities in the same way. And so we have seen a major shift as the society has changed and its preferences have changed. The response has been a democratic one. It has not been a good one from the public health point of view. As Professor Yulin said, we had many more people die than needed to die. But it has been a democratic response, in the sense of responding to different public views as they differ geographically and preventing government from taking over. And I know that the private sector response was pretty good. As I think about this, I think the COVID response should force constitutional lawyers to rethink emergency rule. And I have a table, if you think about the paradigm of an emergency, it's basically a war, a national security crisis. And in that kind of crisis, there's some external actor or maybe an internal actor that engages in violence, and it happens very quickly. And so that means you need a quick response. And the information on how to respond is highly concentrated. If we have a military invasion, we can't have 50 states in the United States or all the states of India making their own response. You need to have a unified national response. And this suggests Oh, there's also, I should say, I note a need for secrecy and a need for coordination across the entire territory of the country, right? That's definitely the case in a war. If you had a decentralized response among all the states, you'd get all kinds of craziness and you'd have a suboptimal response. This means that for a national security crisis, the main actor should be the executive, the national executive, because military can command, everything is concentrated at the center. But think about other kinds of crises. They're different a little bit. In a financial crisis, it also arrives very fast. Its source is a regulatory failure. It can last a long time or a short time. It's also the case that for a financial crisis, because of a national economy, you do need a concentrated central response. And so we usually will see the national actors, the central banks and such, playing a critical role, and regulatory agencies. Natural disasters are quite different if you think about it. Here, it's nature that is moving. Sometimes it's a quick thing like an earthquake. Sometimes it's a slow thing like climate change. And if it's a true emergency, the actual information about what's happening is decentralized. It's not held at the national government. The people living in the affected area know more about it. And the response may be geographically concentrated. You don't need a uniform response across the territory. To me, this means that in a natural disaster, we shouldn't concentrate emergency power at the center, but rather should distribute it. And finally, a pandemic. Again, like a natural disaster, it's and causes it. And it tends to evolve very slowly. And it involves shifting conditions the entire time. As we have seen with this pandemic over 2 years, a very long one. And information about the pandemic actually is really decentralized. Yes, we have, as Professor Yulin said, National Institutes of Health that, gather the public health data and can try to make recommendations. But the fact is that local hospitals are the ones that really know what's going on, and they are feeding information to the center. With war, the information comes from the center and gets distributed down. With a public health crisis, it comes from the bottom up to the top. So a different information structure of the problem. And it may be that you don't need a uniform response across the territory. Professor Yulin talked about different preferences, but it may also be that the pandemic affects different parts of the country differently because of weather or something like that. This means to me that the pandemic response should be decentralized, kind of from economics of information point of view. And we should allow different kinds of responses. And so I think this kind of typology of different kinds of crises is something that we learn and we can take away and has positive implications for constitutional design going forward. Constitutions, when they're written now, should differentiate among emergencies, not treat them all the same, and maybe think about constitutional design in a way that allows a little more flexibility. Before I stop, I want to share one more slide, which has to do with autocracy. During the COVID-19 pandemic, we did see some abuse of the restrictions by certain autocrats. Xi Jinping used this moment to consolidate the takeover of Hong Kong. Hong Kong is part of China, so I understand, that's not an international issue per se, but it did mean that we did see more constraints. President Erdogan in Turkey decided to release prisoners, because the prisons were too crowded and they would be risky for COVID. But he kept people in prison who were his political opponents. So you got released unless you were someone who had criticized him in the past. And Hun Sen used this rules about fake news, spreading misinformation during COVID, to get rid of the opposition party in this country. So there's always a temptation by executives. But in democracies, we see that it tends to work. And finally, this map sort of shows, if you're thinking about the risks to democracy from emergency rule, we know that the failure of democracy correlates with other things: political polarization, history of government instability, recession, poverty, having too much oil, war. And you can see on this map that we can grade countries by the risk of their, I would call them comorbidities, risks to the political system that are caused by COVID. And I think that, India, you see, is red. It's a high-risk country because, of course, it's a very poor country, generally speaking, and, has had some tendencies, right, towards concentration of power in recent years. The United States is also at grave risk. But as the pandemic is ending, I think we can say that institutions generally have held in democracies, and our constitutional system has worked. So that's my presentation. It's, I think of the law and economic with it. Let's see if I can close this. Just want to make sure you can see me. Oh, good. You can see me. And my PowerPoint is down now, or is it still up?
Yes, sir.
So,
So-
no, sorry.
Yeah, please
I
go
almost
ahead.
left I almost left the event. So just to conclude, I think that, what do we learn from this? Many different things, but government is not at risk during COVID as much as we thought. Law can constrain emergency power. Machiavelli was correct. Carl Schmitt was not correct. We see genuine limits on executive power during emergencies. Thank you very much.
Thank you very much, Professor Ginsberg, for your well-connected lecture with the past, present, and also the future, which you are predicting that the COVID is almost going to be over, and the role of the state, the new role of the state, is on the way. So the point is, you have covered all theoretical aspect of human rights, and which was having a very, very challenging time during COVID-19. So I think if Hitesh, if you can help me in getting some questions from the audience, then we can take up some of the questions.
Sure.
Yeah.
Realize it's so late there, so maybe people are tired from the conference. So there's no pressure.
So meanwhile, I have a very small query on your lecture. That what type of healthcare jurisprudence you are finding in the age of COVID-19, when it is true that the impact of virus is declining, but it is also true that the universal vaccine is still very far away.
Yes, I mean, there's a whole set of issues which I did not talk about related to the global situation and the sharing of vaccines and the legal frameworks, therefore. And of course, we saw the Trump administration, for political reasons, leaving the World Health Organization. We've now rejoined it in the United States and are trying to, maximize the distribution. In terms of the law about it, the main issues have to do, of course, with intellectual property, and the conditions under which the licensing would occur. One of the vaccines, the AstraZeneca vaccine, was developed by Oxford University, and there was some discussion at the beginning about having that vaccine be in the public domain, so that a country like India, which is a big leader in producing vaccines and producing the pills, would be able to generate a lot of it very quickly. And unfortunately, the decision was taken that it should go through the pharmaceutical companies. And I think the Gates Foundation may have had something to do with that, that was their recommendation. So I think that was a very bad decision, because it meant that we get less production than we might have otherwise had of the vaccine. So the law does implicate this. But perhaps even more important than law is the politics, where the rich world has to understand that we really are just one planet, you know? And if we don't provide vaccines to the developing world, the COVID is going to mutate and come back to the rich world. And I've actually seen some statistical models which show this, that there's benefit to the rich world by vaccinating the poor world because people move around, people travel. If I travel to, I don't know, Malawi, let's just take that country, relatively poor country in Africa, and no one there's been vaccinated, I will get some variant, I'll bring it back to America, and then we'll have a new pandemic. So in some sense, I think we're learning that it really is one interconnected world. And so the politics, I hope, would support greater distribution to the developing countries even for our self-interest. As law and economics scholars, we always start with self-interest, right? We recognize that people are basically selfish and people respond to incentives. And so I think the challenge is to set up a structure in which the rich countries are incentivized to do what is in their self-interest in terms of providing these vaccines without overly enforcing the intellectual property rights.
So I find, Professor, the war between self-interest of the country and the selfish motivation of certain firms, those who wish to maximize their profit through their patent rights. So how this is going to be tackled within the country, which had the huge power of patent rights today in terms of vaccine, and they have their self-interest involved also.
So actually, it was again, Professor Yulin mentioned that the Trump administration did a very good job in developing the vaccine. And that was because they understood self-interest. They understood that they had to incentivize the companies to create the vaccine. And the way they did that is they promised to buy a certain number of doses. So, you could imagine a government scheme where we say, we're going to buy this number of doses on the condition that the formula then enters the public domain. And that kind of institutional design is perfectly feasible. We could do that. So I feel like it's just a matter of public policy and intellectual property policy, which of course it's not my expertise. I'm sure there are people on the call who know much more about it. But the first thing I think is for the national governments to recognize that we are internationally, that is in our national self-interest to vaccinate everybody on Earth. That's a critical point, a political point that has to be made first. Because only when we realize that can we understand that we have to design a scheme whereby the patents are not enforced strictly and that we did redistribute. And I think, I don't know, I hope that would happen, but it's ultimately involves not just good institutional design, but a political kind of recognition of interdependence. We're in a state right now of horrible, violent war in Ukraine. And I'm very heartened to see that the world is kind of banding together in recognition that, we don't want war. And many companies, I don't know if the Indian companies are doing this, but many Western companies are saying we're not going to do any business in Russia. And of course, that's very bad for the individual Russian people who have no control over the situation. But the reason I bring it up, because I think it suggests that there is a recognition that we are in one world and that you can bring together private sector, public sector together. It's going to be much more powerful than either one working alone. So maybe that will also have some spillover in terms of solidarity with things like COVID vaccines. I don't know, that's optimistic.
So there are two questions in chat section, if Naren sir want to take. So Joya Jahid has asked, what does a more decentralized approach to tackling the pandemic look like?
A more decentralized approach to tackling the pandemic? So I think the answer is that means you must have you know, that you allow responses to vary across the territory, the national territory. And of course, we have to do that in the United States constitutionally. The governor of Florida, who Professor Yulin was criticizing, you know, is maybe reflecting the preferences of his population. Now, again, in law and economics, the design of federalism, we think that if preferences vary across territory, we should have government policies vary across territory. Sorry, the sun is coming up here slightly. It's early in the morning here. That if government policies vary, then if preferences vary, then policy should vary. The downside, of course, is that there's externalities from each jurisdiction. And so I think we have adopted a very decentralized approach. But one of the problems is in a national economy, that means there could be spillovers from the ineffective responses that actually undermine the more effective responses. So it's kind of a trade-off. It's a classic trade-off in federalism design, you know? We might want to reflect preferences, but if there's externalities, then that's a reason for a national level response. And the politics are such that we're unable to do that, or the constitutional design prohibits us or prevents us from actually addressing those externalities. So I think that's what I'd say about the decentralization.
So Dr. Hitesh, do you have any other question?
So there is one other question or comments from Rishi Kumar. He is mentioning yesterday there was one session from Professor Vogel, Stephen Vogel, about emergency power and constitution from the economic perspective. So demonstrating the bicameral legislation actually incentivized the executive to force an illegal emergency rule. So it's asking that bicameral legislation actually incentivize executive to force an illegal emergency rule. So he's asking, do you agree with him as well?
You know, I haven't seen his paper. I'm sure he wouldn't report that result unless it was statistically significant. But I don't really understand the mechanism. I mean, maybe what he's saying is that, you know, because legislation is more difficult to pass in an emergency of limited time, so it forces the executive to act more quickly without, you know, and ignore the legislature. Even if that's true, I don't think it's something that we should, you know, celebrate, as it were. Right? Because remember, even back to the Romans, there was this idea that, oh my God, it's an emergency, it's a crisis. We have to set aside all the normal law. And that's a theme that we always hear. And so the greater risk in emergency is not the failure to respond, it's responding too much in a way that gives too much power to the executive. And the misuse of the claim of emergency in order to get political advantage. So, you know, I don't know what I would say about his result, but I'm not sure that it's convincing in terms of what it would mean for constitutional design. And remember also what I said about those countries where the law runs out. You know, that's just going to happen sometimes. We should not be prisoner to the foresight of the prior legislatures and constitutional designers. If they failed to provide for some powers and we have a true emergency, we have to act. You know, we can't fetishize the rule of law over the health of the nation. What then I would look for is not whether something complies with law or not. That's formalistic. What I would look for is, do the political institutions respond in a way that's consistent with the rule of law values? So Taiwan, they passed a law that retroactively authorized things. If you were really worried about the rule of law as, you know, and so concerned about illegality, you would say, oh my God, it's terrible, it's a disaster. But if you're looking substantively, you're looking for participation, for limited powers, for temporal limitation for oversight, then what they did is just fine. And so I wouldn't worry too much about legal, illegal, but about whether there's genuine constraint on the executive in whatever form it takes. That's my view.
Can I ask one question if moderator permit? Anil sir, can I go ahead?
Please go ahead.
Sir, with regard to the what in the US election, whether if pandemic was there or not, whether this result maybe have remained same, because there was some correlation what we found with regard to in the Ulan sir lecture of vaccinization, a vaccine and context of the Biden versus Trump. So whether that has played any role with regard to the what Biden win in the as a presidential election?
It did play a role in that we had to undertake exceptional steps in order to help facilitate people's voting, right? You had to have longer absentee hours. You didn't want the lines for voting to be a big spread. And to be honest, we have one party, the Republican Party, which not in every state, but in many states, they don't want people to vote. And so they said, that these restrictions were undermining, these steps that were taken to facilitate voting during the pandemic were allowing voter fraud. And this is just a completely false problem. It's just a pure lie. We don't really have much voter fraud in the United States. Most of the recent incidents have been by Republicans, not Democrats. But that helped Donald Trump make his claim that he had won the election when, of course, everyone knows he didn't. And that, of course, then led, I think, to this tension and obviously the attempt to overthrow our Constitution on January 6th. So in some sense, I think COVID did affect our election a little bit. On the other hand, President Trump is the kind of person where no matter what he said, no matter what happened, he would find a way to do that, I think. And so I don't want to blame the crisis of our democracy on COVID. Nevertheless, in the particular instance, the steps that we took have now led to fighting about how we run elections.
Thank you.
So I think, Dr. Ritesh, there is no other question. Chat box.
Dr. Bharti, one last question, please.
Please go ahead. Yeah.
Sir, just going back to the example of Taiwan that you said, yes, law ran out, and yes, the objective of the emergency is met, and there are 7 deaths. What about beyond that? So would that be the limit of this assessment that your session has done, or post that, what are the consequences? So there must have been multiple other restrictions, on people's rights to achieve this 7, which is commendable. So what happens to the rest of those limitations? Do they end? At what point would they end?
Good question. So I have not followed in detail what they've done, but initially they had a lot of tracking, on your cell phone and things like this. They had very strict travel limits. They didn't allow people in and out. You had to quarantine when you came in. And so very, very strict limits on personal freedom, no question. And I think they still have some of those if you were designated. Now, it's nothing like China. If you are in contact with someone who was, had COVID in China, even if you test negative, you have to be isolated in a hotel or some special facility for 2 weeks or plus. It's very strict restrictions. Taiwan's restrictions were less severe, and they were helped because the vice president of the country was a public health expert, an epidemiologist. And unlike the United States, many people trusted the government, and they trusted him in particular. And so they obeyed those rules. So I think it goes back to the theme of the last session, the idea of trust, the idea of good quality decision making. But they certainly haven't led to any kind of executive takeover or anything like that. The president remains very popular. So, I think it was probably a pretty good example. Now, they have good circumstances that the rest of us don't have. They have a high quality government. They have a tradition of trust in government. They're an island. So I'm not saying that we could adopt those same policies. In fact, I don't think we could in the United States and maybe not in India. And so the response in some sense has to reflect the local culture, the local level of trust in the government and such. And in a way, that's what democracy is about, right? The United States chose to have 1 million people die because people didn't want to wear masks. And, Professor Yulin and I think maybe that's crazy, but it is at least democratic. It reflected the local demand and the local preferences, even if those are misguided. And that's really, in some sense, what democracy is about. If I lose in the election, I have to acknowledge the result, even if I think the other person is crazy. So from the point of view of the health of the democracy, if not the health of the citizens, our response was pretty good.
Thank you.
Thank you very much. It was a wonderful lecture and very timely and thought-provoking. So the role of the state, such as India, when the few Indian states are having the election result coming out, the work during COVID-19 was now reflected in the result as it is indicated by the political parties. So the trust in the governance matters during crisis. And this trust has to be again formulated for the further development, further challenges which country like India and other developing countries are having. So thank you very much again for this lively session, a very pinpoint discussion on the theoretical freedom, theoretical aspect of the freedom of the human being, and that too in the crisis time. Thank you very much. So Professor Nagar and Dr. Hitesh, we can now close the session.
Dr. Bharti, thank you very much. You're the only person I have not exchanged greetings with. Thank you very much for the brilliant moderation that you've done. Thank you.
Yeah, thank you very much.
Professor Ginsberg, can we conclude?
Yes.
Thank you. Thank you for your precious session, Professor.
Thank you very much.
Wonderful to see you.
Yeah.
Thank you all.
Thank you.
I want to make announcement to the paper presenter. The best paper award will be announced soon. We are in the process of evaluation process. So after review process, it will be announced and it will be reflected in the GNLU website. So thank you one and all present here. We are very much thankful to the all the audience and moderator, speaker, and everybody. And also thanks go to our team. I think Srey to Isan and Kusi and everybody. I think they are working day and night, and I think credit goes to our center head and everyone that we understood the importance of this conference. And I think in that regard, we are giving our best. So with that note, we can conclude this session. Thank you.
Thank you, Dr. Thakkar, for this very successful conference. All credit goes to you. Thank you. Big cheers for Dr. Thakkar. Everybody.
Thank you.
Thank you. Thank you.
Thank you, sir. Thank you, ma'am. Shall I end the meeting now, sir?
Yes, yes, sir.